So thank you all for joining. I can see a few of you listed on the side, so I won't address you directly, but thank you for joining us. This is one or the latest in our series of Bowman's Employment Club seminars, and the intention behind them is to enable a bit of a two-way discussion about particular issues of employment law. Clearly, at the moment, the biggest thing is still the coronavirus and lockdown. And so for that reason, that is one of the things I'm going to be focusing on. If people have other questions that are related or feel that they wish to discuss, do feel free to chip in and submit them, and then we will see if we can help. Obviously, if it's relevant to the issue, that is all to the good, but otherwise we'll take it forward. So one of the problems we've got, obviously, in relation to the coronavirus and advising on employment law matters is that the law is changing quite routinely or quite frequently. I did this seminar last Thursday for the Chartered Institute of Personnel and Development, and I suspect by now quite a lot of what I said last week is already out of date. But nevertheless, we will see what we can deal with. Just so you know, I think we're listed to run for about an hour and a half, but I'm only proposing to talk for about an hour unless people have other questions they would like us to look at. So obviously at the moment we're in our third national lockdown, which began on the 4th of January, I think it was. And it has a big impact on the obligations that employers have towards their employees. Those are separate to, but very much related, separate from but related to employers' existing obligations towards their employees. And I think it's important to bear those in mind when you're considering how to respond to the current lockdown situation. I suppose the first thing that an employer needs to consider is that they have an obligation to provide their employees with a safe place of work. So employees have the right to be safe at work. And given the impact of COVID on workplaces and obviously traveling to those workplaces, those are considerations that are always going to apply to an employer's behavior with regard to its employees, no matter whether we're in lockdown or if we release the lockdown, as may be happening in the next few months. Even when that happens, there are still going to be steps that an employer will need to take. And we'll come on to some of the ways that an employer will need to address possible return to work in the future. One of the things that we have yet to really get our head around, I think, as a nation, is how we are going to be returning to work, and indeed whether the future world of work will look similar to the way it used to. I imagine that there will be a lot more working from home, partly because employees who are able to work from home, by and large, I think, have been able to demonstrate that they can do it. And I think it will be harder for a lot of employers to object to that, as they have done in the past. But we'll come on to that in a second. The other thing that obviously we'll be looking at is the effect of the vaccine or vaccines, and how that will affect people's return to work. And some people already raised some questions about that I'll come to when we get there. In the notes I'll send you, there is a breakdown of a lot of the guidance that has been issued from the government, from ACAS, and from various other bodies. It's all useful, but the trouble is, when there is a lot of information, it can almost be as bad as there not being enough, because it can be buried amongst a lot of other things that are not necessarily going to be relevant to all employers. And as I mentioned earlier, the guidance has changed, and it's changed from last week, and it has changed a lot since, well, we're coming up to a year since the first lockdown was implemented. And one of the things that was discussed quite a long time ago were the COVID-19 secure guidelines. Now, they were technically removed in September last year, but in reality, the fundamental points of them remain. So I'm just going to go through those very briefly, because these are things that, as I say, they have been removed, but they still are fundamental to how an employer considers how to address its employees. So one of the first things, and it's quite a lot of the law that's come out about COVID-19 is a variation or an expansion on existing health and safety law for perfectly understandable reasons. And the first one is an obligation on employers to conduct a risk assessment. Now, obviously, this is in relation to COVID-19, but as a general rule, employers have a duty to conduct risk assessments about working environments. Um, One of the things with a lot of people working from home is that theoretically, I would say that most employers should really be undertaking a review of people's working situations. Now, for various reasons, not least the fact that a lot of people weren't expecting to have to work from home, certainly not for as long as they have ended up doing. I'm not sure if that has been done, or realistically if it's going to be picked up on. Quite a lot of this law has come as a bit of an emergency proposition, and I think certainly in the next 6 months that will still remain a fundamental background consideration for, certainly for employment tribunals when they're considering whether or not an employer has behaved reasonably. But beyond that, um, we need to ensure that we are, as soon as we can, going back to the main principles of fairness, um, and providing safe places of work. So at the moment we're in lockdown, but it will be lifted at some point in the future. And when that happens, these are some of the things that employers will need to consider. So there is the workplace risk assessment, um, and then there are the other things that we have become very familiar to seeing in the work or out in the world back in the days when we were allowed out in the world. Um, these include things like developing cleaning and hand washing procedures, helping people to work from home, as I've discussed and we'll come on to in a bit more detail, maintaining social distancing, and where people cannot be more than 2 meters apart, which is still, as I understand it, the main guidance, to how best to manage the risk. So there will be situations, obviously, where people have to work closely together, and there are obviously exceptions to the rule at the moment about lockdown, and those exceptions will relate particularly for people in the public sector, people who cannot work from home, who are not shielding, and obviously we are largely reliant at the moment on, particularly on delivery people, obviously on utilities and healthcare and people like that who are not in a position to work from home, obviously. So it's about making sure that employers are able to weigh up what the risks are and put in place some measures that will hopefully minimize those risks. Now, moving forward, obviously vaccination will have an impact, and as I say, we'll come on to that in a second. But we will, I should think, for the foreseeable future, still have to consider ways of minimizing risk when, if and when people are allowed back to normal workplaces. In the immediate aftermath of COVID becoming a full-blown pandemic, and certainly lockdown in the UK, clearly there are lots of things about perspex shields and face shields and face masks. And those things, I suspect, are probably going to remain fundamental for some time, providing hand washing stations, making sure that there is a robust cleaning arrangement. Those things will remain. And I suppose one could reasonably ask why that hasn't been the case in the past. And that the answer to that may just be that people are filthy and disgusting. But I'll leave that to you to determine. But clearly, we do need to keep on top of this because this is a pandemic. It is not necessarily the only pandemic, and these are factors that will probably have to come up. We'll probably have to deal with as we move forward. So I've mentioned risk assessments, and one of the fundamental points about the working relationship between employers and employees, and I will probably come back to it again and again, is about communication. Because particularly where people have been working from home, communication is a vital way of ensuring that people understand what is going on. And one of the questions that has been raised, in fact, I'll deal with it now because I think it's quite useful, is about mental health. And employers have a duty to consider an employee's health in the round. So that's not just physical health, it includes mental health, in the same way that if there is disability discrimination, that doesn't just relate to physical disability, it can also relate to a mental impairment. And the definition of disability under the Equality Act is a physical or mental impairment that has a substantial and long-term negative effect on a person's ability to do normal day-to-day activities. So you can imagine how particularly stress, anxiety, depression, all of these things are fallouts of COVID and have been quite widely discussed in the media. I think an employer needs to be alert to them, because um, it's easy to try and deal with, as I say, hand washing and things like that. But employees are, as we all are, working in an entirely unknown, unexpected, unplanned for situation. And one of the questions that came up is mental health issues amongst staff during the pandemic and managing performance. So I mentioned obviously the risk associated with mental health issues. The main risk, of course, is that if an employee is disabled, then an employer has additional duties to protect them, not to discriminate against them, and particularly in relation to the question of managing performance, I would say one of the key issues is likely to be the obligation to consider reasonable adjustments. And the question particularly relates to managing performance. And clearly managing performance is, we're talking about an employee who may not be performing to their full standard. There are, under the Employment Rights Act, 5 potentially fair reasons for dismissal, of which performance is one. The others are capability, redundancy, statutory illegality, or some other substantial reason, which is the famous catch-all term for, by and large, a breakdown in the working relationship, or where an employee simply cannot continue working for the employer. But in this case, performance is a potentially fair reason for dismissal, but an employer really should follow, well, in relation to most dismissals, I would always advise following the ACAS guide on disciplinary and grievance procedures, because failure to do that by an employer can potentially lead to any award being increased by up to 25%. So if an employer fails to follow a fair procedure and dismisses, then the employee, in addition to potentially claiming unfair dismissal, if they've got the qualifying period of 2 years service, or if there's an argument of discrimination, can also claim for injury to feelings if there's discrimination, and an uplift on any award. So that, apart from the basic principle of fairness, which is a fundamental consideration underlying all employment relationships, an employer has a duty to behave fairly towards their employees. So follow the ACAS code is the first step. The question, I suppose, relates to the possibility that an employee, possibly because of mental health issues, is not performing at their best. And as I mentioned, there is, I think the first thing to be alert to is the risk of disability. If they are disabled, if they have a physical or mental condition that has been going on for more than a year or is likely to last for more than a year, that is going to be long-term and has a substantial negative effect on their ability to carry out normal day-to-day activities. So clearly that is just in engaging with, I was going to say the world, but obviously the world as we know it at the moment. I think the main thing to do is to, in this situation, is probably to consider reasonable adjustments. So I would suggest not treating an employee in that situation in the same way that you might have done, for example, 18 months ago. Obviously, if an employee has stress or depression, then you really do need to be careful anyway, because you have duties towards that employee. Ultimately, if an employee is disabled but cannot do their job at all, then provided you follow the fair procedures, have ideally given them an opportunity or several opportunities to improve, give them a clear indication of where they are falling down, what is expected of them, and ideally support to enable them to comply with those, to meet that standard, then you can still dismiss, but you need to follow the fair procedure. If somebody is disabled, then you need to consider reasonable adjustments. And I think particularly at the moment, these reasonable adjustments could include giving an employee more time or opportunities to improve, maybe even providing additional support, whether that's in terms of IT support or even potentially breaks. Because one of the problems, of course, with working from home, that I've been working from home on and off for the last four or 5 years, and clearly one of the problems is that your living space is not that far from your working space, and it can be very difficult for there to be a break. And anecdotally, I know from clients who have instructed me, they're aware that a lot of their employees are finding it difficult to actually switch off from work. And clearly, for most employers, they want their employees to be able to function well because they need them to do their work properly. And there's a good balance to be struck between actually supporting your employees and identifying where they are unable to do their work. And if there are things that you can do to help and support them do their work, then you should be doing them as possible reasonable adjustments. I would also advise not to leap to conclusions. I've dealt with a number of disability cases from both sides over the years, and the worst cases are always those where an employer has absolutely decided on the outcome before any procedure has commenced. That is always dangerous, and the outcome is usually an unfair dismissal finding and a discrimination finding, and you really do not want to have to deal with that as an employer. The other thing to consider is getting an occupational health assessment to identify whether an employee is likely to have a disability. Occupational health consultants or providers don't always provide that clear-cut definition reasonably, because it's often not up to them to decide. If it were to become a tribunal case, it would be for the tribunal to make that decision. But a good occupational health advisor will nevertheless be able to provide some guidance on whether they think it is more or less likely that an employee will be deemed to be disabled. As an employer, you also should be alert to the fact that if you have concerns about somebody's health and well-being, either physical or mental, as soon as you have the first inkling, you are deemed to have knowledge of that condition. So don't park that because it will either fester in the background and become worse, or if you do decide to move forward and don't consider reasonable adjustments, don't treat the employee as potentially disabled, you will be deemed to have had knowledge of that from the very outset. So do be cautious about that. So that's one of the issues about mental health. The other point I was just going to put in the chat link is ACAS have come up with some guidance on supporting staff with mental health, and I've put the link to the guidance note in the chat section. So if that's of use, do have a look. As I say, I'll circulate my notes after this, and it should have links to quite a lot of these policies and procedures. ACAS is a brilliant organisation for providing guidance and practical suggestions, so I would always suggest having a look at ACAS in any event. One of the other questions that's broadly linked to something that somebody has asked is about who can return to work. Obviously, since the 4th of January, and I had to say I'm broadly talking about England here, simply for the sake of speed. There are potentially various permutations in relation to Wales, Scotland, and Northern Ireland, which I'm afraid I'm not going to address here. But if you have questions about those, then we can probably look at them another time. But for now, as I say, I'm just going to focus on England. At the moment, the obligation on employers is to take every possible step to facilitate their employees working from home. So that includes providing suitable IT and equipment to enable remote working. And at the moment, even though it doesn't always feel like that, no person may leave or be outside their home without a reasonable excuse. Now, I'm not going to get into the politics of it, but clearly there have been some ups and downs as to how much people are abiding by the provisions of lockdown and complying with the obligations to stay at home. But at the moment, unless there are some exemptions, people really should be working from home and staying indoors. Yes, the COVID-19 secure guidelines recognise that working from home is unrealistic for many, and obviously that's fairly clear, including those who work in other people's homes. So, for example, cleaners, carers, and obviously people like I was going to say water, gas providers, people who need to undertake emergency work in people's houses, people who work from vehicles and who provide close contact services. And there is some guidance which I will, as I say, will circulate after this. One of the questions, I'm just going to go on to vulnerable and extremely vulnerable staff, because clearly, certainly at the outset, there were principles of shielding. And technically at the moment, the shielding advice remains unchanged, even for people who've had the vaccine, and I'll come on to that, as I say, in a second. Shielding has never actually been compulsory, subject to the provisions of the lockdown rules. But even at the moment, people who are shielding are advised to stay at home at all times, except for going out for exercise or attend a medical appointment, and to keep all contact with others to a minimum and to avoid busy areas. Now, one of the questions that somebody has posed, and I don't know who asked these questions, so don't worry, I'm not going to name or it's not a question, Shane, but anyway, I'm not going to name people. But one of the questions I had is, if an employee is not a home worker and has been shielding as a vulnerable group and is refusing to have a vaccination, is there anything we can do? They've been on full pay since March 2020. And so there's technically no particular obligation about shielding other than the normal lockdown provisions. My understanding is it was actually suspended from about August last year. And this question sort of raises issues to do with vaccination, which I think are probably useful to go through now. I think the first thing to be said is that the vaccination or vaccinations may not be suitable for all people. There are clearly a lot of concerns about vaccination, and in preparing for this, I did have a read through people who had concerns. As I understand it, none of the vaccines contain any animal products, although some of them may have been developed using animal testing, and clearly people have perfectly understandable and perfectly respectable concerns about that. Even the Vegan Society, though, have recommended people having the vaccine. And just as a general note, I was just keeping up to date with the BBC News because, as I say, the rules on this do change quite routinely. And this evening there is going to be a video being broadcast at about, 4 minutes to 10 on ITV Channel 4 and Channel 5 by a group of people from ethnic minority communities to try and convince people who have concerns about the vaccine that it is worth doing. I'm aware that in certain communities there are rumours about the vaccine. As I mentioned, there are people who fear that they contain animal products. As I understand it, they do not. People who believe that they are not genuine. Obviously, it's reasonable for people to have concerns, and the fact of the vaccine is that some people have some short-term allergic reactions because it is, in essence, a medical procedure. And the very fact that it is a medical procedure will have a bearing on how employers really should consider implementing it or encouraging staff to implement it. The basic principle at the moment is that employees have the right to choose if they have the vaccine. There is no statutory obligation on people to have the vaccine. There may also be groups for whom it is not advisable. I don't know off the top of my head what the rules are about pregnant women, but it may be, as with some vaccinations, that it is not suitable for pregnant women. As I'm not sure on that, but as the guidance and the research develops, clearly that's something to be borne in mind. As a general rule, I would also advise employers not to oblige their employees to have the vaccine unless there are particular circumstances. And the last time I looked at this, I think Pimlico Plumbers had just said that they required all of their employees to have a vaccine. And the reason that they gave was that because plumbers have to go to people's houses, they need to be able to demonstrate or need to be able to prove that their members of staff are not at risk to either their clients or to each other and members of staff. Now, it's very difficult to come up with a one-size-fits-all rule, and I would be very reluctant to do that. I would be reluctant also to advise employers to require all their employees to have a vaccination. I don't see there's any problem in encouraging it. And there may be circumstances, as I mentioned, Pimlico plumbers have tried it. We'll see how that plays out, where it may be useful and bordering on the absolutely essential for employees to be vaccinated. You need to deal with this on a case-by-case basis. And the question that was raised was, as I mentioned earlier, a home worker who's been shielding but refuses to have a vaccination. Now, theoretically, employers could introduce a contractual requirement that employees are vaccinated, but there are always risks with varying contract of employment. And there are three ways of varying contract, and the best and the way I would always recommend, certainly in the first instance, is by agreement. And that requires consultation with the employees, making it clear the reasons that the proposed amendment to people's contract is required, listening to people's concerns, ideally addressing those concerns and overcoming them. So that is the first way. The other way is attempting to implement it unilaterally, which is never ideal. Many employees with certain contractual variations are often very happy to agree to it because realistically it's no skin off their nose. Other employees may object to it, in which case they can formally object to it. Otherwise, they will probably be deemed to have acquiesced to any changes. And then there is the nuclear option of varying contract, which is dismissal and offering to reinstate on the new terms. Now, that is potentially problematic, particularly if there are issues related to discrimination. But the principle, the idea behind it is that most of the awards for unfair dismissal in the employment tribunal are for loss of earnings. So what an employee has lost out on from the date that they are employed until they have found alternative work. And employees have an obligation, or claimants rather, in a tribunal have an obligation to try and mitigate their losses by finding other work. So they can't just sit back, wait for a tribunal claim to provide them with money. The tribunal will expect to see evidence that they have attempted to find other work. So that will be job applications, the adverts they have applied to, notes of interviews, things like that. And the idea behind dismissal and an offer of reinstatement is that the employee, if they do persist in bringing a claim, will theoretically have failed to mitigate their loss because there on the table was a potential alternative role for them, which if they did not accept it, they have declined to take. That is the theory. It can be very messy and I would never recommend it in the first instance. So you can introduce contractual requirements, but there are risks. I think at the moment, if an employee cannot work from home and is unable to agree reasonable alternative arrangements with their employer, then the employer could either furlough them if that is available. And I'm aware that certain public organisations cannot furlough. So, for example, some teachers, as I understand it, cannot be furloughed because they are paid by the government. So either furloughed or put on statutory sick pay, SSP, if they cannot be furloughed. It's inadvisable. I mean, obviously at the moment it's difficult, but it's inadvisable to allow an employee to return to work against government guidance. And at the moment, the national lockdown stay-at-home guidance advises the clinically extremely vulnerable not to attend their workplace. So I think at the moment in that situation, if there's somebody who's shielding but refuses to have a vaccination, one, I don't think you can oblige them to have a vaccination. Although, as I mentioned earlier, consultation I think is going to be key here. I think you probably would need to identify exactly the reason why they are concerned about the vaccination and, if possible, address those concerns. And I'll come on to some other issues related to that in a second. But otherwise, I think probably the best thing to do is to keep them on furlough if you can furlough them, or SSP if not. And it's not ideal, but I think at the moment, a tribunal in an unfair dismissal claim would probably side with an employee in a situation like that if they were dismissed because they refused to have a vaccination and couldn't return to work. And I think they would probably find it unfair to impose a medical procedure, which is, as I say, likely how they would treat a vaccination. At some point, people will be returning to work anyway. And before we get to that stage, it's important, I would say, that employers undertake decent consultation with their employees to find out what their concerns are, how they are expecting to return to work, and really just to give you the tools to be able to put things in place that will allow a return to work. As I mentioned earlier, I suspect that the future world of work will look very different to what it looked like 18 months ago. Um, and I think an employer will probably struggled to insist on people coming into an office where their employees have been able to work successfully from home. Obviously, not all employers have been able to do that, and I know there have been ups and downs. But I think if you are able to demonstrate that you have listened to what people have to say, then you are probably going to be in a strong position. The biggest problems in tribunal cases and in workplace disputes usually come from where an employer has handed down a decision without having considered all of the options. And particularly at the moment, I would recommend trying to hear from your employees as much as possible. It really also goes back to the point about mental health. People are largely working from home, and obviously, a lot of people are feeling isolated. I think employers really do need to go the extra mile to make sure that employees feel valued, feel part of a group, and not just cast out to their box rooms and their sofas to carry on working, because that's clearly not a sustainable situation. Um, and also not to implement proposed changes to the workplace without getting agreement. I think most employers' employees' contracts of employment contain a provision saying that where their place of work is, and they will also usually contain a provision saying that an employer can vary that or dictate where that workplace will be. It's always important where there is such a provision not to exercise it unilaterally, even though you may feel that you have, as an employer, the right to tell someone where they will go to work. If it is has a significant impact on that employee's working life or indeed private life, that change should never be implemented without consultation and ideally getting agreement. And I think employers need to be careful not to assume that they are the only people who know the answers to these questions. Employees know how their working life works and how it impacts on their personal life. So do keep an open mind. One of the other questions that came through earlier was about the crossover with redundancy. And last time we did one of these, and I, like many people, have completely lost track of time. I think we're in February, but it could easily be July. The last time we did one of these, we discussed redundancy, and I think that the video should still be available on our website. So if you would like to have a look at me wittering on about redundancy, go and look that up. But the question that was raised, particularly in relation to the current situation, was where funding is reduced, and thoughts about options: redundancy versus furlough, so delaying problems and still costing the employer, versus consulting to reduced hours to match lower funding levels. There has obviously been a lot of talk about redundancy at the moment, because people are concerned about businesses continuing to be viable, and that is absolutely understandable. And obviously in 2008, 2009, when there was the financial crash, there were a lot of redundancies. I think I said before, my experience at the time was that a lot of employers were being more creative than they had been before about considering alternatives to redundancy. And I think particularly at the moment that an employment tribunal would probably expect an employer to go out of their way to consider alternatives to redundancy, simply because the situation we're faced with at the moment is unprecedented in most people's experience. Certainly not for 100 years have we had anything of this nature. And you do not necessarily have to dismiss somebody. There are alternatives, and I'll come to those in a second. The other important thing to consider is the definition of redundancy. For many years, I think it's happened less and less, but it used to be the case that some employers would use redundancy with bunny rabbit ears as a so-called nice way of dismissing an employee. because they felt that it didn't attach blame to the dismissal in the way that misconduct or capability did. That is always dangerous, and I would advise against doing that. Redundancy has very specific definitions. A redundancy situation occurs where there is a reduced requirement for a business to employ a particular person carrying out a particular kind of work, where there is a closure of a workplace, or where an employer is closing down altogether. Unless you are dealing with any of those three situations, you probably are not facing a redundancy. So never ascribe to a dismissal the wrong reason, because if you do, you will probably find that you have not got in place the right rationale to explain it and to excuse it. As I say, there are 5 potentially fair reasons for dismissal, of which redundancy is one. They are all of them only potentially fair. If an employer follows a fair procedure, then even if it is for the right reason, it may still lead to an unfair dismissal, and a tribunal may still award compensation against an employer who has not followed the right, who's not dismissed for the right reason. So for that and for many other reasons, do not make someone redundant if it is not a genuine redundancy. That I suspect probably addresses the main point about this question, redundancy versus furlough. If the business is still operating and people are needed to do that work, then you are not in a redundancy situation. If you have 5 people doing that job and you only have need for 3 people to carry on doing it, then you probably do have a redundancy. You have a reduced requirement for the number of people to carry out a particular kind of work. And if that is the situation, then you need to go through the formal redundancy process. Otherwise, it would probably be advisable to consider furlough where you are able to do that. Furlough is itself a variation to a contract of employment, so it really needs to be agreed in writing. I haven't discussed this for a little while, but I would suggest making absolutely certain, if you are an employer and have put people on furlough, that you have a written letter. It's not particularly complicated. ACAS may even have a copy on their website confirming that they are agreeing to go on furlough, and keep it under review. At the outset of lockdown in March, lost track of time again, but in 2020, when lockdown and furlough began, from an employment perspective, I've been doing this for 16, 17 years, and furlough was an entirely new concept other than in American films. So we were not familiar with it as an idea. And when it first came into force, it was quite a blunt instrument. It was all or nothing. We've now moved on to flexible furlough, which hopefully gives employers a bit more, as the name suggests, flexibility. So that is, I would suggest, in the first port of call if you can. I think, although the tribunal process is very slow at the moment because it was massively underfunded and grinding to a halt even before this began, things have not improved with lockdown and courts closing. They're up and running again now, but they are still working quite slowly. We're largely doing remote hearings, particularly at the moment, which take, well, I'm not going to say they take more time, but they are a different enterprise, and they are much more exhausting to conduct. But anecdotally, there's a large increase in the number of claims that have been submitted. There was a backlog anyway, so claims are now already being listed. I had a case preliminary hearing earlier in the week. We are now listed for a hearing in 2022. So we do not yet have any of the claims that have been lodged, as far as I'm aware anyway, in relation to furlough and unfair dismissal relating to COVID, although they will come through. But I would imagine, and I would expect, that most employment tribunals will look at the possibilities open to an employer if they have made people redundant, when they could potentially have put people on furlough. The other thing with a genuine redundancy is that employers have an obligation to look at alternatives to redundancy. And again, it's important when entering into a redundancy that there is a consultation process. It shouldn't just be a tick box exercise. It is really supposed to be an opportunity for the employer to lay out the situation in which they believe they have found themselves, the alternatives that they have found themselves, and to listen to what the employee may have to say. Um, and as with my earlier comments about consultation, it's vital to actually listen to what the employee has to say, because if the employee comes up with a perfectly sensible reason or sensible suggestion for how their job and those of maybe their colleagues can be saved, or how they may not be made redundant, so it could be an alternative role, job share, all these sorts of permutations, I think an employer is likely to be criticised if they do not consider them sensibly. And it being a little bit awkward is probably not a good enough defence, particularly at the moment, given that we're facing a serious recession and job losses. I think most employment tribunals would likely consider that the employer has to go that extra mile, because the implications are probably going to be quite serious for individuals and also possibly for the wider economy. So that is what I would suggest about redundancy. Um, yes, and my other note is careful not to use redundancy when that's not the reason. So so that is those are the questions that I've had in beforehand. If anybody out there has any questions, do feel free to raise them. If you wish to do them anonymously, I realistically don't know how we can do that, but I'm sure we could find a way. So unless anyone has anything else, I will carry on for a little bit, but I think we're getting close to the sort of the end of my notes for now. I was just going to go back to vaccination. We have under the UK employment law protection against discrimination for people with protected characteristics. One of those protected characteristics is religion or belief. And we have had cases about people for whom veganism is a belief and that is a protected characteristic. But just having an opinion or a thought does not necessarily equate to having a protectable or protected belief. But I would be very surprised if there are not people who I'm going to just summarize as anti-vaxxers who will complain that they've been discriminated against because of their belief that vaccines contain microchips or are controlled by Bill Gates or whatever other strange views people have. And as I mentioned, it doesn't have to be a religious belief to qualify for protection. There have been some guidance, and I'll just quickly go through the headlines of what a belief has to be to qualify for protection. This has come out of case law because it's not particularly well dealt with in the legislation, but it is binding. But some of the suggestions are that the belief must be genuinely held. And the tribunal isn't really there to consider the validity of the belief, but it needs to be genuine. It must be a belief, not an opinion or a viewpoint based on the present state of information. It must be a belief as to a weighty and substantial aspect of human life and behavior. And I mentioned the vegan case. Clearly, that is a weighty and substantial aspect of human life. At the very least, it relates to animal welfare. It relates to food, and obviously that's quite fundamental to human life. It must attain a certain level of cogency, seriousness, cohesion, and importance, and it must be worthy of respect in a democratic society. So you can see the sort of things that are considered. I mean, there are various other points, but I'm not going to go through them for now. But as I say, I would be very surprised if somebody doesn't at least attempt a claim like that in tribunal. And I think just all I would suggest is be alert to that risk. It's my personal opinion is that people who have that belief are not enormously serious, or at the very least are misguided. That is my personal view, and I'm not suggesting it's necessarily the firm's. I'm not even suggesting that's necessarily the right opinion, although I think realistically, and looking at the wider principles about protection, and this is one of the things that we'll come on to in a second about vaccination, is that I think a tribunal will consider the wider human or the wider impact of vaccination and how important it may be to enabling the protection of life and society returning to some form of normality. So, as I say, I have no particular notes on that other than it's just a suspicion based on some of the things that people have attempted to claim they are protected to, some of the beliefs people are claim to have protection to hold. maybe a permutation of those words, but I hope you get where I'm coming from. One of the other things to bear in mind about vaccination is personal injury risk. It's still early days in relation to the vaccination. People have had side effects. As I understand it, so far, none of them are long-term or serious. Arguably, certainly not as long-term or serious as long COVID, which obviously at the moment we are in early days of as well, but appears to be have a very serious impact on people's lives. So we need to sort of bear that in mind. And I would just urge caution not to, as I say, not to oblige employees to have the vaccination. But if you do, then collective consultation is probably the way forward to ensure that nobody can complain that they were forced into it and they didn't have an opportunity to raise their concerns. One of the sort of final points I was just going to address is, as I largely related to that, is the question of whether an employee can be dismissed or disciplined if they refuse to work on health and safety grounds. Now, this is slightly different from the question I addressed earlier about somebody who was shielding and refused to have the vaccine. It is possible that an employee's refusal to attend work due to a belief that they will be at risk of contracting COVID-19 could be protected under Section 100 of the Employment Rights Act, because Section 101D of the Employment Rights Act protects employees from dismissal on the grounds of absence from work if that absence was due to a reasonable belief that attending work would put them in serious and imminent danger. Now, an employee doesn't have to demonstrate that a risk or a danger actually existed. It's enough for them to have a reasonable belief that attending work would put them in danger. Now, clearly there are various bits and pieces that go with that. And one of them will be being able to demonstrate to an employee in that situation the steps that an employer has taken to provide a safe place of work. And that, at the risk of repeating myself endlessly, that is going to be a matter of consultation to be able to demonstrate these are the things we have done. We are taking care, we are doing spacing, we are recommending vaccination. At the moment, the vaccination is being rolled out by the NHS, God bless them. But it may well come a point in the future where it's something that private organizations will be able to offer in the way that employers back in the day, people were in offices in the way that employers offered with the flu jab. As it goes on, it may be something that employers will be able to do, but this will be these are some of the things that an employer will need to demonstrate to be able to prove. And this comes really back to the point I made at the outset about a risk assessment. It's identifying the risks, listening to what employees' concerns are, and then being able to demonstrate that you have taken steps to mitigate those risks. The other point related to that is how people get to work. And obviously, there are concerns about public transport, and those concerns may get those concerns may get less as time goes on and the uptake of vaccination increases. At the moment, the vaccination has been for people in older groups. I think it was originally people over 80 and then 70, and obviously it's working its way down. And in doing that, it's working its way towards the larger. Excuse me, I have to let my cat into my study. Come on now. Good. Do apologise, but she's very important. Yes, so the vaccination will be coming towards the working population more and more, and that is likely to have an impact on, as I understand it, the findings already are that the impact of vaccination is having a significant effect on the amount of people with the condition, and clearly the more people who get it, the better it should be. So these are things that an employer will need to consider and will need to be able to demonstrate. And I think particularly for employees who have to travel quite long distances using public transport, it is probably still going to be, for the foreseeable future anyway, reasonable for an employer to consider continuing to offer working from home provisions as part of that amelioration of the risks. And I suppose that really comes back to the final point about how people will return to work and variations to people's contracts. And I think in the long term, if it is going to be the case that people will work from home either all the time or for a number of days in the week, then once we move out of the emergency period of dealing with COVID, that is something that probably will need to have a much more thorough impact on people's contracts of employment. And certainly at the beginning of all of this, people were somewhat winging it, and that's entirely understandable and perfectly acceptable. But the more permanent these things become, then I think it will be very much very important to consider updating people's contracts of employment, and also to look at policies and procedures, because by and large policies and procedures are not contractual, so failure to comply with them wouldn't be a breach of contract. And if anyone has contracts that are contractual, I would urge you to consider, by agreement with your employees, varying that, because technically if you fail to follow a contractual policy absolutely to the letter, you would be in breach of contract, which is a world of pain that you do not need to get involved in. But moving forward, I think we probably will need to have specific COVID policies, or certainly COVID sections relating to health and safety policies. And bear in mind that not only do employers owe their employees a duty of care to provide a safe place of work, they also need to make sure that they are not putting their employees at unnecessary risk, because the best way to get good work out of employees is for them to be happy. And obviously they need to be skilled and all of these things as well. But where you have an employee who is stressed and unproductive, you are not going to have a productive workforce. And then we come on to the issues about managing performance. And just to go back to that initial question, finally, I think given the impact on COVID on people's mental health, employers do need to go that extra mile at the moment. And I think they are likely to be criticised for leaping to conclusions and for dismissing when there are alternatives, or at the very least, they could be expected to have taken a little bit more care with how they treat their employees. So other than the notes, which, as I say, I will circulate to people afterwards, the key, I would say, is to enable communication and to make sure that you are taking people's thoughts into consideration before making any decisions. It's also about the safety and welfare of all employees, not just individuals. So it's probably still early to say in great detail or absolutely determine what the impact will be of vaccination, but it is likely to have a good impact. And if an employer wishes to oblige their employees to take it, you need to be able to demonstrate you have thought about it carefully, conduct a risk assessment, and that the motivations behind those decisions are reasonable and clearly understandable, and also proportionate. So at the moment, do stay at home unless you can't. Stay safe, and hopefully at some point we will see you in person somewhere. But for now, unless anyone has any questions, I will say goodbye and give my cat some treats. But thank you very much for attending, and hopefully see you some other time. Thank you.